you know, and after like the whole dying in jail and stuff, like all the times, like it just kind of set me on a different path. I don't want nothing to do with it, you know? And like, that's kind of like another reason why I want requesting in-home confinement is because you never know what kind of people they put you with in there, you know?
All right, Mr. Mann, we are set today for a pretrial conference. You're not here. Why are you not here?
Well, there's a few reasons for that, sir. You know, one of the main reasons is I'd like some clarification on the record to be made without getting arrested due to the last appearance. As you know, was physically unable to get there. You're right about my motion. I didn't prove the just cause. I realized that I had to include some exhibits and proof that of what was going on, and I apologize for that. However, the last appearance, I was specially appearing to, by special appearance, I was attempting to make a, by a special appearance to challenge the jurisdiction of the court due to several issues that have been unaddressed through the entirety of the case. The main ones being the discovery violations, you know, the most recent changing of the discovery files to make all my motions look like I don't know what I'm talking about, and kind of confused a lot of the matters. And it's still the same thing. I mean, just a couple days ago, I got notice that there was another discovery update. I mean, we're well past the motions deadline, and you know, there was a discovery update a week before that, and then another one like a week after, and then now more recent ones. And you know, I just don't really feel like that's really granting me a fair chance at really defending myself when they want to change the names of the files and things like that, as I've like already had submissions that had, you know, certain citations to their body cam footages and things like that that have also been unaddressed. You know, it doesn't really provide grounds for fair defense or a reasonable amount of time to be able to defend myself.
All right, thanks, sir. All right, here's, I guess, the record I'm going to make. We're set for trial to commence on Tuesday. Mr. Mann, I recognize how you are perceiving this, but I think the record is pretty clear. This case has been going on since 2022. By my count, there are at least 8 failures to appear, and that's at least 8 failures to appear in this case. You've after an Arguello advisement, you've agreed to represent yourself. You were advised and cautioned during the Arguello advisement that you would be required to, when representing yourself, to comply with the rules of criminal procedure, with any rules of evidence during the admission of any evidence. That has not actually even become ripe at this point because we've not had any hearings. This matter's been set for hearings to address your motions on a couple of occasions just since I've been the presiding judge over this case. And I believe in, let's see, let me just want to make sure I'm, yeah, on 11/26, that just myself have granted you extensions to file certain motions, giving you specific deadlines. And on 11/26/2025, I made it very clear what the final deadline was going to be for your motions to be filed, specifically 12/12/2025. Then we were scheduled for a motions hearing on 1/9/2026. That was the day that you appeared via WebEx. I found a failure to appear because you appeared via WebEx and did not give a adequate reason. You had indicated that you may be able to get here by 10:30, and I even stayed the warrant to give you that opportunity. Today, we're set for pretrial conference 1 week away from the beginning of the trial date. You're still not here in person. These motions that you keep on talking about could have been addressed appropriately if you would have followed the court's orders during that time frame. And certainly, if there are issues of discovery that have happened that are not in compliance with Rule 16, the court will hear those. But those, again, you've been complaining about, or challenging, I should say, discovery issues, but you never present yourself on a date that we're actually scheduled to address those things. And you have to be here in person. You also have to be here in person for the trial. So again, we're set for a pretrial conference here. I have a jury questionnaire that I'm going to submit to the jury commissioner in preparation for Tuesday's trial. I'm going to bring in 55 jurors for that trial. And the court will be prepared. Well, let me ask the prosecution. Is the prosecution ready to go to trial on Friday? I'm sorry, on Tuesday.
People are ready, Your Honor.
All right. So, Mr. Mann, we're set for trial. I mean, this, again, I'll address any pretrial issues or any discovery issues that have arisen in the last 35 days to determine whether there was any discovery violations. One thing you need to understand is the prosecution has a duty to continue to provide discovery. Oftentimes when they provide discovery just based upon, and I don't know how you're receiving your discovery, but again, these are just things I'll consider. And I'm just saying this for your information. Sometimes when they provide discovery, if they're doing it over what they call evidence.com, which is a system that they use to disclose information, sometimes not the new discovery is provided, but then all the previously provided discovery kind of tags along with it. So it's included with it. I will address any discovery issues that may have arisen in the last 35 days, if there's any new discovery that may exist. But those are things that I have to address when you're here in person. You're not here in person. I think I know you're aware that you have a warrant based upon the orders, the motions you filed and the last order I issued in this case. But we are set for trial on Tuesday. You have a right to a trial, and the court, and it looks like the prosecution are prepared to proceed on that date. I will provide you with every opportunity to defend yourself at that trial. We will see you on that date. At this point, I don't know that there's anything else I need to go over pre-trial unless Ms. Jones and again, Ms. Jones is here only as advisory counsel, unless there's something in particular that Ms. Jones you think I should be covering, or unless Mr. Duncan wants anything in particular covered. The one thing I will state is just based upon the nature of how things have been progressing in this case, I'm not going to require any witness testimony on Tuesday, so that at least there's a one-day window there for the people to just place any witnesses on call for what's going to happen the rest of the week.
Sorry, Judge, I don't mean to interrupt.
Yeah, no, I'm actually done with that.
Okay, I should have interrupted sooner. If Mr. Mann is not here today, are you finding that it's a failure to appear?
It is a failure to appear. I'm just giving him the information so we can proceed on Monday. He's got a warrant already. So yes, it is a failure to appear. But I still want to pass the information along so we can proceed on Tuesday. I said Monday. On Tuesday's the trial date.
So, excuse me. You said quite a bit there. I didn't really get a chance to respond to anything.
There's nothing to respond, sir. I'm just giving you instructions.
I got some things I need to address with the court before we can proceed, sir.
Well, sir, then you need to come to court. We will address those things when you're here in person.
Well,
I'm not going to.
I'm trying to tell you guys need to prove jurisdiction, because there was a period of time I sat in prison for almost 9 months and there was no action on the case. That's a failure to prosecute. And I understand the statutory provisions on speedy trial, but there's constitutional provisions. And if the trial ain't had from the date of the start of the case between 180 days and there ain't good cause shown, that means you guys waive jurisdiction.
I will address, sir. I'm asking covered everything I need to cover.
I'm asking you to address it now, because before we can proceed, I need you guys to prove that you guys have authority to try the case.
Sir, I've already addressed way more than I needed to. You're not actually here. It is a failure.
No, I am here.
I am protecting your right to a fair trial.
You waived my rights to all my motions. Without me even knowing it. I didn't get proper notice of that waiver of rights. You can't just be taking people's rights. The Constitution forbids that, and Constitution trumps everything. It doesn't matter what kind of order or ruling of law. If it's against the Constitution, you know that you can't be ruling like that. So can you address that, please?
All right, sir. What I'm addressing is that you're not here And the one thing I will say is you were on notice as to what the motions date was, and you failed to appear on the motions date.
Well,
You have
no,
to be
actually,
in
I
person.
attempted to appear
in
by
court.
video because I couldn't get there, and I wish the record would reflect that. Because I did try.
Sir,
to,
the record is made on this case. Okay. This matter is now in recess.
Okay.
You have a trial on Tuesday. You need
That's
to be
cool.
here in person for your trial.
Yeah, I got you. You don't want to
All
give
right.
me nothing. I got you. That's pretty much unfair as it gets.
Here as advisory counsel for Mr. Mann. Mr. Mann is not in the courtroom. I guess I'll just ask, do either party have any information relating to Mr. Mann as to why he's not here today?
No record,
Okay.
Your Honor, that I
All
can
right.
make on his behalf. I don't represent him.
No, I understand. Just didn't know if there's any communication or anything, but all right, we're set for trial. I'm going to make well, let me find out. Is there any record that, and Ms. Jones, I 100% recognize that you don't represent him, but is there any record you need to make of any kind?
Your Honor, I have been in touch with Mr. Mann as he has been attempting to prepare for his trial this morning throughout the long weekend. I know that he is scared, he is confused, he has many questions about how to proceed as a pro se individual. I did my best to try to assist him in that manner, but I don't represent him.
No, it's fine. It's fine. I just, all right, I need to make a record. So, because frankly, based upon the nature of this case as a whole, I think the court needs to take some appropriate action on the bond issues on this case. So I guess I'll go back to the last court date, which was on 2/10 of 2026. Mr. Mann, that was set for a pretrial conference. And Mr. Mann, at that point, kept on arguing or was trying to argue that the court lacked jurisdiction, and based upon what he was saying, he indicated because the case has not been brought to trial within a certain period of time. He was presumably making some kind of a speedy trial argument. So the court believes that it's relevant to make this record both to establish why, at least based upon the court's review of the record, there's not ever been an issue of speedy trial in this case, and two, why at this point I believe a new bond. I mean, he's already on a bench. There's already a bench warrant that has been issued in the case against him, but the court finds that a bond modification is now required for his failure to appear at trial. It was made very clear to him on 2/10/2026, even though the court found that he failed to appear because he was on WebEx, the court at least gave him the courtesy of explaining to him how jury selection would go, the fact that there's a trial and that he was expected to be here for the trial. This case has been set for trial now 4 times. This is the 4th trial setting. The first trial setting was continued. Well, he pled not guilty back in 10/10 of 2024, so October 10 of 2024. And most of this is based upon the court's review of the record. That's when he pled not guilty. The trial was set for 9/25/2024. I'm sorry, I just confused the record here. I'm sorry. On 4/10/2024, he pled not guilty. Speedy trial was then 10/10/2024. And the trial was then set on 9/25/2024. So before the speedy trial date. There was a 35 days, an order from the court for the defendant to file motions 35 days prior to the motion setting date, which was set on 8/2/2024. That matter was continued at the defendant's request, and a second trial setting was then set. So the new speedy trial date on the second trial setting, which was set on 7/30/2024, then became 1/30/2025. That new trial date, I'm sorry, that was a new speedy trial date. The new speedy trial date was now 1/30/2025 with a new trial date of 11/13/2024. New motions date of 10/4/2024 and a pretrial conference date of 10/25/2024. The defendant failed to appear to the motions date, to the pretrial conference date, and the trial date for the second trial setting. The defendant then next appeared on February 28, 2025. The matter on that date was set for a setting on 4/7/2025, and the judge that presided on that date ordered that speedy trial was tolled until the next court date. So the speedy trial then was 10/7/2025 per that court order. The defendant failed to appear on 4/7/2025, which was the setting date for that trial date, and a bench warrant was issued. The defendant then appeared again on 4/9/2025, and on 4/9/2025, the defendant indicated that he was hiring private counsel, but may go pro se. So the court advised the defendant pursuant to Arguello, and the matter was set for trial on 9/10/2025. And it appears from the record that the defendant accepted the trial date that was set on that date. Court again set motions due date 35 days prior to the motions hearing date, which was then set at 7/11 of 2025, and a pretrial conference on 8/26/2025 was set. The defendant failed to appear to the motions date of 7/11/2025, failed to appear at the 8/26/2025 pretrial conference date, and failed to appear to the now third trial setting, and second failure to appear on a trial setting by the defendant that was on 9/10/2025, and that was a waiver of speedy trial. So now we're set on the fourth trial setting. The defendant was arrested on a warrant on or about 9/22/2025. On that date, the court saw the defendant. He indicated he had motions to file. Since the court was set the matter for trial, the new speedy trial date, which is the speedy trial date that applies to this particular trial setting, is 3/23/2026. The court appointed advisory counsel, Ms. Jones, well, who ended up being Ms. Jones. I don't think she was identified on that date, but who ended up being Ms. Jones, and allowed the defendant an opportunity to file motions to show cause as to why motions should be allowed to be filed late, and set the case for trial on today's date, so 2/17/2026. 26. Pretrial conference was 2/10/2026. On 9/23/2026, the defendant made clear that he did not want the public defender to represent him, and again, he had been previously given an Arguello advisement. Court then set 11/24/2025 as a date for which the defendant could file motions, if good cause could be shown for any delays. Court then set a status conference the day after those motions were due on 11/25/2025 to allow the defendant to basically have a status on where we were on motions. And on 11/25/2025, the minute order will be corrected if it hasn't already. The minute order at one point was reflecting it was on 11/26/2025, but the court has actually gone and listened to the FTR. It was on 11/25/2025 that the defendant appeared in court, and the court extended the deadline for the motions to be filed further to 12/12/2025, and set this matter for a hearing on motions on 1/9/2026 at 9 a.m. So on the trial setting here, he had the hearing on motions date of 1/9/2026 at 9 a.m. He had the 2/10/2026 date for the pretrial conference date, and then today's date for the trial. The defendant failed to appear at the hearing on motions. He appeared via WebEx, which the court indicated the court would not accept, and the court gave him about an hour and a half to get to court after he stated that he may be able to get here, and the defendant did not show on that date. The defendant then appeared to the pretrial conference, as previously mentioned, via WebEx, and the court indicated that, again, that was a failure to appear, and the defendant needed to be present. So the court deemed that to be a failure to appear. But again, the court at least used the opportunity to try to increase efficiencies on today's date if the defendant appeared for trial. And Ms. Jones specifically had asked that the court do this. The court did provide him with the procedures that the court uses for jury trial. So this case is now set for a fourth trial setting since the defendant first entered his not guilty plea. It's been continued once at the request of the defendant, and speedy trial was waived, and at all other times it's always been continued because the defendant has failed to appear to every single hearing after the first trial setting, to every single hearing that dealt with either a motions hearing, a pretrial conference, or the trial, including today. So as this is now set for its fourth trial setting and the defendant is not here, the court believes that a bond modification is required for what the court has previously posted, because it is clear the defendant will not follow the court's orders on such important dates that are actually set up to protect the defendant's rights to a speedy trial, which is what he keeps complaining of, but he's not, based upon the record, the court finds that it is his doing as to why this case has not proceeded to trial more expeditiously. And so the court modifies the bond at this point to $100,000 cash bond.
We're calling two cases, 25 CR 2733 and 22 CR 2848, People versus Mann. This is from the Division E docket. It comes on for appearance on arrest warrant. I'll take entries starting with the people.
Will applicant for the people.
Thank you.
And Jessica Jones as advisory counsel for Mr. Mann, he is pro se.
Okay, thank you, folks. This matter comes on for appearance on an arrest warrant as noted, following failure to appear for jury trial scheduled on February 18th. I'll note that the court found a waiver of speedy trial on that date. Speedy trial will begin to run again today. So for the record, speedy trial will be August 26th, absent any tolling or waivers. Mr. Atherton, how are you asking to proceed, sir?
Your Honor, in speaking with Ms. Jones, and I understand Mr. Mann is pro se and she's serving as advisory counsel. I was going to ask the court if we could set this matter over until tomorrow. I know this court is covering for Division E tomorrow as well. I don't know what this court's docket is like, but the reason for that is Mr. Duncan is assigned to these cases. He has very intimate knowledge of the cases. He's been working on them for a long period of time. He's out today. It was, a surprise that Mr. Mann was on the docket today. I know he was recently arrested, so not too much of a surprise, but I do want to give Mr. Duncan the opportunity to handle anything on the case and be present for this if the court could accommodate and if that's what Mr. Mann would like to see as well.
Okay. Mr. Mann, what would you like to do, sir?
Well, there was a deal put on the table, and everybody's aware of the deal in the case. So, if we could just simplify this matter and I could just bite on that deal today. It was a plea guilty to DM1 and a 22 CR 2848, and then a DF4 in the other case. And I'm prepared to take that deal right now. If we can just simplify everybody's time, and we can just go ahead and do immediate sentencing too.
Okay. And so I can't get involved in plea negotiations, but Mr. Atherton, your position on that request.
Sorry.
And that's what I was kind of referring to. I didn't want to get into too many details for that reason, Your Honor. Mr. Duncan previously made FRI records in the case, so that's what I want to give him the opportunity to figure out and be present for.
Okay. So given that Mr. Duncan is not available this morning and the nature of the add-on this morning, I do find good cause to continue this to tomorrow. So we're not going to have significant delays, but it sounds like Mr. Atherton can't move forward on any prior plea offers. I'll leave that to the people of Mr. Mann and Ms. Jones to discuss, but we'll continue this to tomorrow for setting. Speedy trial will still be running, so you won't be losing any time on that speedy trial date. Go ahead, Mr. Mann. Did you have something else, sir?
Yeah. One other thing is I'd like to address the bond, because there was an issue where, I don't know, to my understanding that this whole trial is going to be reset then, is that correct?
Yes, there's not a resolution.
Basically, they're going to start over from motions and all that. Is that what's going on, or what's the procedure on this?
Well, I can't say for sure because, I'm not Judge Hernandez. I didn't preside over all of the hearings. If there are motions that need to be relitigated, we can set a new motion.
So the issue I'd like to address is the bond. Basically, there was a deal where I had an outstanding warrant in another jurisdiction the day of motions hearing, and I tried to go get that handled before I came to the motions hearing. Well, there was a snowstorm that night, and I wasn't allowed to travel the next morning, made it so I was not able to handle either one of them. The judge basically issued that I had an hour to get to the courthouse the day of the snowstorm, and I tried to do that. I didn't make that either. So then they decided that I waived my right to motions hearing. Well, I put in a motion to quash that warrant, and I would like to basically say that, you know, I'd like to readdress that with this court because, you know, I showed good cause on why I couldn't make that 1 hour deadline. And I believe that basically I didn't run on this case. I didn't try to hide. I didn't do nothing. They found me right at my house. I didn't try to resist. I didn't do nothing. I told them they knew right where I was going to be because I don't even hardly leave my house because all I do is work on this case all day and night. So basically, I'd like to ask that bond be reinstated and the warrant quashed from that moment so I could proceed from what happened before that. Basically, I think would be like a abuse of judicial discretion on part of the judge on not letting me quash that warrant, because that's the only reason why I missed the trial is because they wouldn't let me just reinstate my bonds. They wanted to basically have me pay more money, which is basically a form of extortion when they know that, like, basically it was just going to restore me back to where I would have been at before all this happened.
Okay.
So I'd like to ask for basically to restore the original bond of the, what was it, 30,000 cash surety, and basically have all judgments since then vacated, voided.
All right, thank you, Mr. Mann. So I'm going to take what you said into account. I'm not going to address bond today,
That's okay.
but we will continue to tomorrow. We'll address bond tomorrow morning as well. If there's not a resolution. One other thing, I think there was a request to reconsider Judge Hernandez's rulings concerning failure to appear at motions. With regards to him finding a waiver of any sort of motions, I'm going to have to defer to Judge Hernandez on that. I'm not going to do that, but we can address bond tomorrow morning as well.
Because I think they got me on a no bond right now. At least that's what the jail said.
Okay, that is incorrect. So I do see bonds set on 22 CR 2848 at $100,000 cash only, and then on 25 CR 2733, bond is set at $20,000 cash or surety. So that's the current setting of bond.
Okay.
It's not a no bond hold.
If you guys could just update that with the jail, that'd be cool.
And this is 25 CR 2733 and 22 CR 2848 on the Division E docket. This matter comes on for the hearing on bond or status. Mr. Duncan, I'll let you update the court in terms of where things stand. If you're aware, perhaps Mr. Mann can update us.
I'm not sure what Mr. Mann is planning on doing today, Judge. I did provide advisory counsel, Ms. Jones, some paperwork in case he decided that he would like to resolve the cases by plea today. And so that's the information I have for the court right now.
Okay. Mr. Mann?
Yeah, I'd like to proceed with the plea agreements as stated by Mr. Duncan.
And Mr. Mann, in the 22 CR case, looks like there's an agreement that you'll receive a sentence of 36 days in the Adams County Jail and receive 36 days of pre-sentence confinement credit without any additional incarceration there. Is that your understanding?
Yeah, but I think the total is a little wrong, but I'm not sure that it matters at this point.
Okay. I think functionally it sounds like the people won't be asking for any additional jail in closing this case. Is that your understanding?
That's my understanding.
Okay. Mr. Duncan, is that accurate?
That's accurate.
Okay. I'm willing to be bound by that agreement, but do understand that beyond that, any other terms and conditions still could be up to me.
Yes, sir.
Okay. And it looks like there's no sentencing concessions in the other case, so do you understand that the sentence in the other matter will be up to me?
Yeah, I think so, yeah.
Okay. If you're not sure about that.
Yeah, that's right. That's
Okay. All right.
yeah, sorry about that.
That's all right. Just want to make sure we're all on the same page.
Yeah, no, we are.
Is anybody forcing you or putting pressure on you to make these pleas?
No, sir.
Are you under the influence of any drugs, alcohol, or medication affecting your ability to understand what's happening?
No, I'm clear head.
Okay. Any other questions for me or Ms. Jones at this point?
No, sir.
All right. Thanks, sir. Then in 25 CR 2733, as to count 2, a class 4 drug felony, how do you wish to plead guilty or
Guilty.
not guilty? Thank you. I'll accept the plea. And in 22 CR 2848, as to count 5, class 1 drug misdemeanor, how do you wish to plead guilty?
Guilty, sir.
Okay. I'll accept the plea in both matters, find them to be knowing, intelligent, and voluntarily made. Mr. Duncan, were you prepared to move forward with sentencing, sir?
My request was going to be to set it into Division E on Monday, Your Honor. I understand if the court doesn't want to do that today, though.
Okay. Mr. Mann, what's your request in terms of
I'd like to go right now today. If I would ask Mr. Duncan proceed first, if that's okay.
Okay, that's fine. I'm happy to hear from people first. Go ahead, Mr. Duncan.
Thank you, Judge. I think the sentencing options for the court under the subsection of the DF4 statute that's been pleaded gives the court the option of a probationary sentence, of a jail sentence as a condition of probation not to exceed 90 days, or a DOC sentence. I'm not asking the court to impose a DOC sentence. I don't think probation is appropriate here, given Mr. Mann's history, and I can go through that if the court would like me to. Mr. Mann has spent quite some time in and out of DOC in recent years, and so during his time with Westminster PD, when he was being transported, he'd indicated to them that he had no interest in treatment, and as soon as he got out, he was going to get high again. That was in 2022. I don't know where he is with his sobriety today. Obviously, in the 25 case that we're talking about here, he was in possession of around about 15 grams of a combination of fentanyl and methamphetamine. I don't know if that was his for use or how he came into his possession, what he intended to do with it. But I just don't think that Mr. Mann is going to be successful on probation. I don't think we want to set him up for that failure and have him back here again. And so I'm asking the court to impose a jail sentence as a sole condition of probation, and I'm asking the court to impose 90 days jail. Mr. Mann may have 3 or 4 days of credit on this case, and so my request is 90 days jail as the sole condition of unsupervised probation. I don't believe the alternative sentencing options are available under this part of the possession of a controlled substance statute.
Thank you, Mr. Duncan. Mr. Mann,
Yeah.
what would you like to let me know, sir?
Well, this case is kind of weird because I had actually like 4 years sobriety before this incident happened. This incident happened in the jail where this person, it was a cellmate, ended up throwing these drugs at me just before a shakedown in the cell, and I didn't know what to do, so I smuggled these drugs through the shakedown. I ended up with these drugs or whatever, and it actually impacted my life like majorly. I ended up overdosing and dying like 4 times in the jail. Like I said, I had 4 years sobriety before that. Like I was doing good. Like I was off parole. Like everything was good until I came back on this revocation for missing my trial and stuff. Brought back on the warrant. Sorry, I'm real emotional about this, but like everything was good, and this guy talked me into bringing these drugs to, trying to sneak these drugs through so I could get the bond money to get out. And like it wrecked my whole life, really. Like I almost died. Like I died like 4 times, between the jail and going to the ER and stuff. And like, I just wish I would have never met this person that they put me in the cell with, because I don't think this whole situation would have happened. But other than that, like Mr. Duncan said, this is an old case from 2022. Since then I went to prison. I did the sober house. I did good ever since. And I would just ask for really just like an at-home confinement so I can continue working with like trying to get back into the school. I was trying to do some college. I enrolled and stuff, but I kind of put it off to the side because I didn't know what was going on with my legal things and all that. And then I also have some other job opportunities it's called Swipe Joy. It's a credit card processing company. They offer low rates for businesses and stuff like that. I've also been involved in. I'd like to just be able to ask for like at-home confinement in order to be able to like keep my home proper, like basically like I wasn't on these warrants and stuff. I didn't run. I didn't try to hide. I told the bondsman, like, if you guys need me to come in, just tell me when and where, because I've been trying to figure out how to get these warrants handled. It started when, like I said yesterday, with the Denver case. I ended up missing the Denver case, and I didn't know about it because I scheduled the wrong date in my calendar like a fool. And I got the notification for the court date through the text program. They do the, well, I forget what it's called. They send you updates to your court dates through Colorado system. I can't remember what it's called though. Anyways, I missed the court date for Denver, and I couldn't get the consented surety for the Denver case until the day of the motions hearing in this 22 CR 2848 case. So I tried to handle them both the same morning. Like I said, there was a snowstorm, and I've been working with the bondsman. I've been keeping them updated with my info. I didn't try to run. I didn't try to take off the bracelet. I didn't do none of that. I told them exactly. They know where I was at because I hardly ever leave my house. You know, because I got things that I work on there, like, and basically, like, I think at-home confinement would be the best. 'Cause then I can basically help, because we're in the middle of restoring the house so we could sell it and move away after all this is done. Me and my lady, I wish she was here, but she's not. But anyways, like, that's basically what I'm asking for, is either at-home confinement or some type of, I mean, I got no problem. I didn't run on the GPS. I didn't try to take, I told them straight up, if you guys need me to come in, like, I'll come in, just tell me when and where. And I didn't try to like buck. That's why, like, when the bounty hunters came, I didn't try to resist. I told them, like, look, I told them to just call me and tell me to come in. I'll come in anytime, anywhere. So I wasn't trying to run. I wasn't trying to like hide. I mean, I was at the same place the whole time. I guess, sorry, I'm so worked up about it.
You're fine, Mr. Mann. Take your time, sir.
Yeah, I tried to. You know, that's why I'm requesting home detention, I guess, is because it's really just the best option.
Okay, thanks, sir.
And it's like kind of not really a major crime, you know what I mean? And like I said, I was sober up until all this happened, you know, and after like the whole dying in jail and stuff, like all the times, like it just kind of set me on a different path. I don't want nothing to do with it, you know? And like, that's kind of like another reason why I want requesting in-home confinement, is because you never know what kind of people they put you with in there, you know?
Okay, thanks, sir. Thank you, folks. I've considered the arguments of both parties. I've reviewed the files in these matters. First, as to the 22 CR matter, it's an older offense. Given the procedural history here, I do agree with both parties. The recommendation here is appropriate. So in 22 CR 2848, I'll sentence Mr. Mann to a period of 36 days in the Adams County Jail with 36 days of pre-sentence confinement credit. As to 25 CR 2733, the original charge here was a Class 6 felony of introduction of contraband. Mr. Mann has explained some of the circumstances there. I think some of Mr. Duncan's requests certainly are fair. Any controlled substances in the jail are obviously concerning, and I think Mr. Mann has even identified himself some of the risks there with, it sounds like some of the medical issues that Mr. Mann suffered alone. But obviously, that's a significant concern, particularly with fentanyl. I do agree with Mr. Duncan. I don't see probation being a realistic option here, and I'm just not sure that Mr. Mann would be successful. The question is whether Department of Corrections is an appropriate sentence given the level of the charges and the nature of what occurred here. So I do find that some sanction is appropriate, but I don't find that Department of Corrections sentence would really benefit Mr. Mann in terms of treatment, and I'm not sure that it would help the community on the back end. I do think Mr. Mann has already suffered some consequences. I do think some additional sanction is appropriate, but I think simply some additional jail is appropriate. I have considered the in-home detention, Mr. Mann, but I just think given some of the concerns I've already noted, I don't think in-home detention is appropriate either. So I'm going to sentence Mr. Mann in 25 CR 2733 to a period of 60 days of unsupervised probation. Sole condition will be a 60-day sentence in the Adams County Jail. I have calculated 28 days of pre-sentence confinement credit from looking at September 26th to bonding October 15th, and then the recent incarceration from the 24th until today's date, so additional 3 days there. So I'll apply 28 days towards that sentence. So you'll still have some additional time, Mr. Mann, but then you'll be released and these matters will be closed. I will impose the drug offender surcharge as to both matters as well. I do find that Mr. Mann is currently indigent, and as to any court costs and fees, I do find that he may be unable to pay those in the reasonably foreseeable future, particularly given the drug offender surcharge. So I will waive any waivable costs and fees with the exception of victim compensation and VAST. So there will still be some court costs and fees to be responsible for on that, Mr. Mann.
All right, thank you.
Thanks, sir. Do you have any questions for me about the sentence there?
No, I just got to do like, what, 50 days?
I think about 32 days remaining, less any good time credit.
All right, thank you.
Thanks, sir. And those will run concurrent to each other. Mr. Duncan, anything further?
Nothing further.
Okay. All right.
Mr.
Thank you,
Duncan.
folks.
Good luck, Mr. Mann.
Thank you.